Hello, regulation theory students. Dr. Conway back for lesson 6, regulation and national legal frameworks. In this section, we're beginning to switch in the course to what are still theoretical propositions, but are applied in practice as to how regulation should work in a liberal democracy. Okay, so what we want to do now is start to situate our work in the broader legal framework of the country. All right, so let's get started on that question now. Okay, now in all democratic countries, at least democratic countries that have a written constitution, legal infrastructure applicable to the study of regulation is comprised of the constitution, legislative acts, and laws of general application, which apply to all policy instruments. Okay, I think we all know that the Constitution is the highest law of the political system. Typically consisting in Canada, for example, in a federal system, the Constitution consists of rules governing the relationship between citizens and the state and between different parts of the state. Because when we're talking about a federalist system, we have division of powers between levels of government, right? And that is certainly applicable to Canada. The Canadian Constitution was patriated from Great Britain in 1982. It consists of written documents, court decisions or precedents, which they're called precedents in common law, and unwritten conventions, informal and uncodified procedural agreements that are followed by state institutions. Okay. Together, these constitutional components describe the basis and method by which political representatives are chosen, the scope for legitimate state power, including how it is limited, i.e., vis-a-vis citizen rights, collective and individual, and in particular that's embodied in the Charter of Rights and Freedoms in the Canadian Constitution. The division of powers in the Canadian Federation also must be addressed by the Constitution. Constitutional division of powers between levels of governments and branches of government. It's important to realize, because we have that distribution of powers written right into our national constitution, we have to realize that that means that the provinces are not children of the federal government, right? Municipalities are the children of provincial governments, but provinces are not the children of the federal government. The provinces have their own constitutional powers in the national constitution. So they are governments that stand on their own tax basis and their own legal basis with respect to a constitutional division of powers. And why is that important? Well, that's very important to regulators, right? Particular regulators at the federal level, because regulation then, the power of regulation by the federal government is circumscribed by the powers contained in the Constitution relative to those powers held by the provincial governments. So it's virtually impossible to develop regulation in Canada, either at the federal or the provincial level, that does not take the federal division of powers into consideration, right? In terms of limiting areas where regulation can occur based on the powers that government holds within the Constitution written large, the written Constitution, precedents, and so on, all right? So the constitutional authority to make laws and to tax is divided among the national government and the regional governments, which for us are the provincial governments. Okay? But in some cases, the Constitution is not as clear in areas where regulation occurs quite extensively. For example, the environment is not mentioned in the Constitution, believe it or not. Okay, so, basically the departments of various levels of government have had to try to leverage the powers of that government to enter into the environment sphere. So the federal government might enter into the environment sphere by protection of fisheries or transboundary issues or international negotiations, or the power to spend, the spending authority of the federal government, and other mechanisms are used to influence the area of the environment. On the other hand, the provinces will enter into it through their own powers on natural resources, on commerce, and on things like that, right? So environmental legislation, environmental regulation has tended to appear before the courts quite often because that division of powers is not clear in the Constitution. Therefore, it has to be sorted through indirectly through other powers that the governments control vis-a-vis they're mentioned in the Constitution, okay? Some key powers of one level of government can be used to both help out or encroach on the powers of another level of government. So you'll often see that the federal government will complain about the federal government's, the provincial governments will complain about the federal government's spending authority, because the federal government can use the spending authority to imprint upon provincial jurisdiction. For example, in health, provinces are responsible for health, but the federal government also has a national interest to participate in health. And the way they influence the provincial government's health policy is by saying, if we give you 30 or 40% of your health expenditure, we expect the health system to look sort of like this, right? So that would be an example of where the federal government would use its spending authority, but it does it in a number of other areas to influence and to have a cohesive national approach to important national issues, like public health, like the environment, and so on, all right? But because of this federal dynamic, of course, federalism, constitutional federalism, is always in flux and is never in practice fixed in stone in all areas. You know, many political science scholars would describe federalism as government by continual negotiation. Okay, which is not to say it's a bad thing. There can be significant advantages to forcing governments to come to a solution that best suits the local interest and the national interest, right? Many political scientists would argue that there's value in that, whereas others might argue that it's much better to have a unitary state where one level of government can direct resources accordingly, like maybe you see what you see in Great Britain, for example. Okay, but in a federal system, that's not the case, all right? And it's important to understand that the provinces have their own power base, right? They have their own law. They're not children of the federal government. The federal government in itself does not control the provinces outside the federal government's specifically mentioned powers in the Constitution. So federalism, because it's constantly in a situation of negotiating or coming to compromise or understanding about issues, it has to be sustained through an elaborate set of institutions and processes through which political and policy decisions are made and implemented. That also applies in the case of regulation. Some of these mechanisms will be very formalized, like the Council of Ministers of the Environment and other kinds of things like that, which are more formalized, ongoing. But a lot of the negotiation that occurs between federal and provincial government would be what we would call more informal or episodic in negotiation. A new regulation is going to be developed, say, on plastics. You know, the federal government would never advance a regulation like that without consultation with the provinces in terms of how it's going to be implemented on the ground, whether there's going to be any pushback from the provinces, all of these things. Just because there's going to be pushback from the provinces, it doesn't mean the federal government doesn't roll forward. We certainly see that today in the carbon tax, right? But we see that in environmental impact assessment. We see that in approving pharmaceuticals for the market when provinces want faster approval. We're seeing that right now in COVID-19 testing, where Health Canada says they're not happy with a lot of the at-home testing mechanisms or tools, and the province is saying, we need them now. And so there's that tension that occurs, right? Because it's national and it's transboundary, the federal government has jurisdiction over approving those things at the federal level, okay? Whereas the provinces are trying to deliver health services at the provincial level on the ground. So that's bound to be some tension there, right? But first, there's also regular meetings of first ministers. The prime minister and the premiers also meet periodically to address national issues of the highest importance that transcend single ministerial mandates. Now, you have to realize that from our perspective, what this means is that when you're in a regulatory environment and you're a regulator at either level of government, this is the diffuse political and power base that you must work with to achieve a regulation. It's not just a question of saying, oh, identify a harm and therefore I can do anything I want about it, right? I mean, there's a division of powers. The federal government has a sphere of powers that they can operate with, so do the provinces. And sometimes when you're developing a regulation, it impinges on both, right? So there's rarely is there a regulation that's what we would call a medium or high impact regulation developed in Canada that does not involve federal provincial negotiation in one form or another, formally or informally. Okay? Now, There's also regulation is also pitched in a broad sort of ministerial melange of different ministries, right? I mean, we have in Canada we have numbers of different departments and agencies. At the provincial level, it's the same thing. So when you're advancing a regulation, you're negotiating within your own government, and you're negotiating with other levels of government. Okay, and so. Regulation, as you recall from our first lesson where we talked about the political dynamics of power in a political system and how in liberal democracy it's quite diffuse, right? Dispersed. Other people, other organizations, other sectors have their own power base. So when you're pitching a regulation, you're trying to do it in that broad context. So people say, why does it take so long to develop regulations? Well, there's a reason it takes for so long to develop regulations and get them approved all the way up the chain. Okay. Now, speaking of the chain, what is the chain of approval within the federal government? Okay. Branches of government is an important consideration when you're studying regulation, right? The executive branch, the prime minister, and the cabinet are obviously, very important, right? Then there's the legislative branch, which is the Senate and the House of Commons, right? There's the judicial branch, which is the courts and especially the Supreme Court. And these are often called the machinery of government. So when you're developing regulations, and this will be replicated at each provincial government, although probably in smaller scale in some of the smaller provinces, obviously. But it's the same kind of a process where we have lots of different departments and agencies. They have to be coordinated from somewhere, right? And that's the executive branch, the legislative branch, the judicial branch, which resolves disputes about regulations and policy instruments. All right, so all of these things have to be taken into account. Now, the executive branch is the main decision-making arm of government, right? Including advancing bills for legislative consideration and directing and overseeing day-to-day operations of the administrative arms of government, which are essentially the bureaucracy, right? That pool of experts, including most regulators, right, will reside within those administrative arms of government or departments or agencies, right? The executive branch can propose a bill, right? It's proposed to the legislative branch for a new legislative act or a proposed change to an existing legislative act. Why is this important to regulators? Because all regulations, as you've learned, must be developed under the authority afforded by a legislative act. There was a time in history where regulations were incorporated right inside legislative acts, okay? We obviously evolved to more of an enabling legislative framework for which policy instruments are given the authority to be developed later on after an act is passed. And the reason that we do that is because, legislations, even though regulations can be hard to develop and change, they're nothing compared to having to develop and change legislative acts. So we don't want to have to be changing an act every time we want to change a regulation, particularly when you see the legislation in the context of the process I'm just going to describe to you in a minute. When adopted by the legislative branch, bills become legislative acts constituting a portion of the country's law. This is important to us because, as I say, regulations must be developed under clear authorities established within legislative acts. And in turn, legislative acts must be consistent with the provisions of the highest law of the land, which is the Constitution, right? That's why we call it the hierarchy of law. Constitution, legislative acts, and tertiary law, of which regulation is included, all right? So regulations are developed under the authority of legislative acts by administrative departments, the bureaucracy, and agencies overseen by the executive branch, all right? So a minister of cabinet is responsible for that bureaucratic department that is in the position to develop the regulations based on the authority that that department has to operate under the powers of a legislative act. Okay? So administrative departments and agencies, the mandates for which are set out in founding legislation, develop and implement regulations under these legislative authorities. Okay? Obviously under the direction of the minister. That's part of the executive branch, being part of cabinet, okay? To manage the diversity of administrative organizations, the federal government has 4 central agencies: the Prime Minister's Office, the Privy Council Office, Treasury Board of Canada Secretariat, and the Department of Finance. Each one of these has a role in the ultimate approval of a regulation, all right? The central agency moniker or name is applied to designated organizations that have a central coordinating role, like these agencies do. Okay? For example, the Treasury Board of Canada Secretariat oversees coordination to regulatory policy standards of all regulations developed in the federal government. The judicial branch, on the other hand, the courts are not involved in the development of regulation, although they may be asked to give pre-decisions on important issues. For example, a government may refer a question to the court before anything moves forward to avoid dispute or discrepancy, right? But generally speaking, the judicial branch are involved in resolving disputes in the implementation of laws and regulations, and for our purposes, laws, but it's other policy instruments as well. But for regulations from our perspective, okay? So in summary, there's a dynamic and important relationship around the branches of government from a regulator's point of view, just as there is between levels of government from a regulator's point of view. The government makes and administers our laws, legislative and executive branches, and the courts apply the laws when setting legal disputes, the judicial branch. Okay? The departments, the government departments who develop the regulation are used to implement the regulation. All right? Again, reporting to a minister, that's part of the executive branch. But if there's disputes, that can be referred to the judicial branch, and the courts can make a decision on whether there's a transgression of the division of powers between government departments, whether there's a transgression of the rights of citizens, whether there's a transgression of the mandate of one department as opposed to another. All of these things can come under dispute, and then the courts will look at the Constitution, they'll look at the legislation, they'll look at the design of the regulation, and they'll come up with a decision. The court will come up with a decision, all right, on that dispute. Now, the reason that we don't want regulations to appear within legislative acts, and instead we want what we call enabling legislation that sets out the powers to address an area of concern for which the legislation has been developed, right? Like the Canadian Environmental Protection Act is developed to control environmental contaminants, particularly toxic contaminants in the environment. So that is the broad objective of the act. But now regulations need to be developed under that enabling legislation to actually implement the act, okay? Acts cannot be implemented devoid of the policy instruments that are later developed to implement the provisions of that act, okay? And that is where regulation begins to fit in, right? So when the Environment Department develops regulations to implement SEPA, it's drawing, the powers for that regulation are being drawn from the Legislative Act. That says, the Legislative Act says you can do this to address a harm. Regulation is developed consistent with that. But that regulation still has to be approved in that broader context, the federal provincial power, interagency power, following sign-off rules as it goes up to finally be approved by cabinet committee, okay? But so the reason we don't want legislative acts to be embroiled in the details of a regulation is because legislation takes a long time to develop, right? Longer than regulation. And regulations can take 2 years or more, okay? So how do acts of parliament get adopted? Well, first, introduction. The process begins when a bill is introduced to the House of Commons, typically by the executive branch. Doesn't have to be. There can be private members' bills. But generally, private members' bills are rarely adopted fully by the House. They can be, but it doesn't happen very often. Usually bills are proposed to the House of Commons by the executive branch, which is the Prime Minister and the Cabinet, right? A cabinet of ministers, right? So the bill goes through a first reading, right? For the first time without debate and is printed, okay? That in itself can take some time. Second reading, the principle of the bill is debated in the House. It is then voted on. The bill is sent to parliamentary committee for subsequent study. So you can imagine, right? This can go, that part alone can go on for 2 years, all right? Committee stage. A committee hears witnesses, examines the bill clause by clause, and submits a report recommending the bill be accepted as is or with amendments, or that it not proceed any further. You know, bills can be killed at the committee level, all right? But the committee say it's going to go forward. Let's say it's going to go forward. Report stage. Additional amendments to the bill may be moved and debated and voted on in the House, all right? And that can take sometimes, acts now go back to the drawing board, all right? And remember, when we're trying to encourage voluntary consent, not only at the regulatory stage, but at the legislative stage, we want comprehensive expertise. We want public transparency, public legitimacy, so that the people buy into the act, to the law. All right. Third reading will occur. Okay, the bill is debated a final time and voted on in the House. So you can imagine, this has gone around. It has to get on the House's order paper, which is busy. So this can take a considerable chunk of time. It's a humongous effort to develop a whole new piece of legislation, right? So message, once passed, the bill is sent to the other house, the Senate, and the Senate does that all over again, what we just described, right? When the process starts again for the first reading, and the Senate goes through the similar process. When the Senate kicks it back to the House and says, this is what we recommend, that's when the executive will go to work saying we agree, we don't agree, and so on and so forth. And ultimately the House will vote on the act, right? With amendments or non-amendments, depending upon the Senate's recommendations. An unelected Senate in Canada, okay? So then there's the Governor General gets the bill, or a deputy gives the bill royal assent. In other words, it's going to become law in Canada, all right? So when we look at that process, we can see that the legislative process takes a long time. So that's why we don't have policy instruments embedded in legislation anymore, right? Legislation is now drafted more in a framework or enabling legislation that sets out why the legislation is there, what we're trying to achieve with it, and the powers that that legislation enables for people to implement what the act is calling for, all right? And legislative acts can be quite long, right? They can be quite beefy documents, and they can be quite technical. But generally, all of them will, in one way or another, address these following factors, right? They'll talk about purpose and objectives of the legislation. I just described that for SEPA, okay? Scope and coverage. They have to define under the Constitution the specific scope and coverage of that legislative act to make sure it's consistent with constitutional division of powers, right? Not only division of powers between governments, but vis-a-vis the rights of citizens, vis-a-vis the power of the government, all right? Remember, the Constitution has those two elements to it, right? Defining the rights of citizens vis-a-vis the power of government, and defining the division of powers between levels of government. So the act needs to be consistent with that. So the scope and coverage of the act needs to be consistent with the highest law of the land, which is the Constitution in a federal state. The act will lay out key legal principles. Why are those legal principles? Because if there's a dispute before the courts will always look at the intended purpose and objectives as set out by Parliament, and the key legal principles will also help them guide on making a decision. Okay? Clear, accurate, up-to-date definitions will also be important to the court. What do you mean by toxic substances? Well, Parliament approved this definition. Okay, so the court's going to interpret the conflict based on the dispute based on that definition, that purpose and objectives, that scope and coverage, those legal principles, those legal definitions. And so those need to be very carefully crafted in any piece of legislation. All right. All acts will talk about public and private sector responsibilities under the law, because as we know, there's no government can implement all aspects of a law, right? So the law needs to be clear as to how much the federal government can compel others to act, right? While the government is doing its part, right? So legislation will lay out public and private sector responsibilities as defined under the law to address the specific issues and objectives of the law, consistent with the principles, the definitions, and so on, okay? The designated primary authority of the law will be mentioned. For example, for the Canadian Environmental Protection Act, the designated authorities are two ministers, the Minister of the Environment and the Minister of Health, all right? The scope and type of policy instrument that can be used under the law. That's the enabling aspect, right? It says that to achieve these issues and objective consistent with all of these other factors we have in the Act, here are the policy instruments that you can use, all right? And it will also talk about delegated authorities under the law. Sometimes a law will have a principal authority, administrative authority, which would be a minister or two or three ministers, but other elements of the act can be delegated. All right. So they can be delegated to different levels of government. They can be delegated to different branches of government. Still, the powers are still under the authority of the primary administrative authority for the law. But there can be delegated authorities. There are also delegated authorities within ministerial departments. For example, under CEPA, health bureaucracy is delegated certain tasks, and the environment bureaucracy is delegated other tasks under CEPA. Okay? Then to what extent are there powers for implementation of policy instruments? So, the Act may lay out inspection authority, which is the basis for compliance, promotion, and enforcement procedures. All right. Record keeping and reporting requirements. Who has to provide what records? Who has to do what reporting? How long they be kept on record? Are they confidential because of commercial confidentiality reasons or not? These things will be laid out in the Act, and then they would be subsequently reinforced within any regulatory requirement for reporting or anything like that. The Act will also lay out enforcement authorities, for example, confidentiality requirements, appeal processes under environmental actions, under enforcement actions, all right? Now, all laws in a liberal democratic country that adjudicate or compel action to address a problem need to have appeal processes according to basically the dominant laws of the land, the Constitution, and in laws of general application, which I'm going to talk to you about now. All right. So, in addition to the Constitution and legislation and how it's developed, in Canada, regulators also need to be aware of what we call laws of general application. This is something a lot of regulators aren't as familiar with as they should be. But if you're involved in government at a relatively senior level, you're very sensitive to these issues. Certainly Ministry of Justice and the Treasury Board of Canada and senior officials in regulatory departments will be aware of these things. But a lot of people observing regulations from the outside will not be as sensitive to these things, including some people who are teaching regulation. But laws of general application apply to regulation design and implementation because the courts presume that they apply except when some other act says otherwise. So in other words, when you're developing a piece of regulation, you do not need to repeat all of the provisions of all these laws of general application because the courts will automatically presume that these are predominant laws. These are higher order laws that will apply to any regulation that's developed in the Government of Canada. If we didn't have something like that, regulations would be this thick, right? We don't want regulations that thick. So, and also in legislative acts, laws of general application can apply, unless, as it says, that law itself is approved for an exemption from certain aspects of the other law of general application. So the courts presume that they apply, except when some other act says otherwise. They support values found in Canadian society. That's the way the courts interpret laws of general applications. Regulators can rely on solutions that these laws provide instead of having to develop their own solutions in terms of due process. Okay? So in Canada, the most important laws of general application applicable to policy instruments, including regulations, are the Criminal Code. Okay? The Criminal Code is not only about criminal offenses, but also addresses rules of procedures for investigations, warrants, conducting trials more broadly, etc. Which, for example, environmental regulations would typically have compliance, promotion, and legal enforcement procedures. The regulation is not going to set out all those things because those things are already in the Criminal Code, right? Due process considerations under the law are already in the Criminal Code, right? The court will just presume those apply. And even if you try to write something different in a regulation, well, one, it won't be approved through the Justice Department, Treasury Board, and the Cabinet. But let's say that one happened that way, the courts would still say the law of general application takes predominance over that situation. Obviously, right? No regulation is going to supersede the Criminal Code. No, the Criminal Code is going to supersede the regulation, obviously. The Interpretation Act for the Criminal Code stipulates that the legal rules of procedure must apply to offenses created by any federal act or regulation. All right? So right there, this is a law of general application. Doesn't matter what other legislative instrument the regulation is being developed under, what government department or agency is responsible for leading that regulation. It doesn't matter. All offenses created by any federal act or regulation are subject to the rules of procedure of the Criminal Code. Okay? The Financial Administration Act is another major example, okay? This act provides the legal basis for the government's financial management accountability. It also establishes two departments, the Department of Finance and the Treasury Board. And the Treasury Board is mandated with the responsibility of overseeing all federal government regulatory activities. Do they develop them all? No. The regulatory departments that have the expertise develop them. But the Treasury Board maintains the Cabinet's rules with respect to how regulations are to be developed and presented through the various departments that have to sign off. We'll learn about that more, primarily in the second term, and ultimately get approved by Cabinet. Okay? And regulations should not duplicate the provisions of this act with respect to how it authorizes fees to be prescribed for government services or facilities. Those would be fines, cost recovery charges under regulations. All of those things would not be stated in a regulation because the Financial Administrative Act already says in the Government of Canada, this is how it's done. All right. Obviously, that's a good thing. You don't want like 400,000 different ways of collecting things or fining or whatever, right? Any sophisticated modern government will have something like this. All right. The next big one, and it's a very big one for regulators, is the Interpretation Act. The Interpretation Act prevents the repetition of rules that apply broadly in every act and regulation. In other words, you don't need to keep repeating these things because through repetition comes error. This act deals with these things and it's going to apply to every policy instrument that the government develops. Okay? The act stipulates two especially important powers from a regulator's perspective. The power of departmental officials to exercise on behalf of the minister presiding over that department powers conferred by the law on that minister. That minister is the principal authority of that act. Those powers transfer to that department so that the minister can rely on his or her technical experts to develop the regulation, and that's consistent with the Interpretation Act. The power of regulation making authorities to amend or repeal regulation is also addressed by the Interpretation Act. Okay? Now, that Interpretation Act, a very important act from a perspective of the study of regulation. The Privacy Act, another one, another law of general application. This act protects the privacy of individuals, including corporate entities, with respect to personal information about themselves held by federal government institutions. A regulation cannot supersede that. Okay, so when you collect information under a regulation, say from corporate entities or whatever, you know, how you treat that information as a regulator must comply with the Privacy Act. Even if the regulation doesn't say anything about that, the courts will interpret the Privacy Act as being predominant on this question with respect to any government policy regulation, policy instrument, or in particular a regulation. Okay, it also provides individuals with the right of access to that information. All right. So the Privacy Act is also very important for regulation. Now, the Statutory Instrument Act is obviously a very big one. This act provides for the examination, registration, publication, and parliamentary scrutiny of policy instruments, including regulations. This Statutory Instrument Act is the broad parameters of how legislation and policy instruments must be developed in the government. Okay. In compliance with the Act, the government makes regulations public via registration with the Clerk of the Privy Council and publishing in Canada Gazette. You know Canada Gazette 1 and Canada Gazette 2. You must be learning that in your other courses. You'll certainly learn it a lot more in the two courses that I offer in the second term. Right? Gazette 1 is notification of the government's intent to develop a policy instrument in an area. Gazette 2 is the publication of the approved policy instrument. All right. So all of these legal contexts become very important for a regulator to understand. You have to situate regulation in this broader political dynamic of federal-provincial division of powers, of division of mandates and powers between departments and agencies within the very government itself that's developing the regulation, and the laws of general application that dictate how things must be done and the limits on how things must be done with respect to policy instruments. And all regulators need to understand this legal context, right? To be able to understand how regulations are ultimately developed and approved. And one can also see through all this maze of activities that this is one of the reasons that I say that ultimately all regulation is fundamentally political. right? Because it has to run through this political machinery of government. So therefore, we're often balancing that public interest, private interest. The need to advance an objective through this maze means that we have a harm we want to address, but what comes out the back end is never going to be 100% perfect in addressing that harm, okay? It's going to be a question of getting as much harm reduction as we can through a process that is a division of powers. It is a political process. It is informed by science. But science can tell us where we are, but it can't tell us where we, what values we place on where we are, or what's going to come out the back end of this regulatory process. All right. So keep that in mind when you're studying, regulation. Keep the theoretical context firmly in mind, but also realize that politics, regulation must occur through this political environment that will also have a great deal of shaping effect on the regulation. All right. So let's end it there for today, and we'll pick it up again, and I'll see you next time. Okay. Bye bye now.